Distinguished representatives, I declare open the second plenary meeting. Today we will continue the consideration of Agenda Item 7, the general debate. States are invited, in accordance with Rule 50 of the Rules of Procedure of the Assembly, to deliver statements of no longer than 5 minutes. Pursuant to the Bureau decision taken on 7 September 2022, the general debate is scheduled to take place this afternoon and tomorrow in the morning and in the afternoon. Given the experience from recent sessions, the modalities of holding the general debate include the pre-recorded videos or in-person statements. States in a position to do so are invited to submit written statements only, which would be posted on the website of the Assembly. Further to the Bureau decision, dated 2 September 2022, all in-person general debate speakers in a respective category would be given precedence. The statements via pre-recorded videos would follow. The updated list of speakers can be found at the conference officer's desk. Let us proceed immediately with our first speaker, His Excellency Mr. Jan Lipavsky, Minister of Foreign Affairs of the Czech Republic, who will speak on behalf of the European Union. Your Excellency, you have the floor.
Madam President, I am honored to address the Assembly of States Parties on behalf of the European Union and its members. The candidate countries, Republic of Albania, Montenegro, Republic of North Macedonia, Republic of Moldova, Republic of Serbia, and the country of the stabilization and association process and potential candidate, Bosnia and Herzegovina, and the EFTA country, Kingdom of Norway, member of the European Economic Area, as well as Principality of Andorra, align themselves with this statement. In this capacity, I would like to express our thanks to the Presidents of the Assembly, the President of the Court, the Prosecutor and the Deputy Prosecutors, and congratulate them on the important work done during the last year. We assure them of our steadfast support. I would also like to take this opportunity to thank the Registrar, Mr. Peter Lewis, for his time at the ICC and express appreciation for his tireless effort towards the effective functioning of the Court. We commend his outstanding work. As we celebrate the 20th anniversary of the entry into force of the Rome Statute, we reiterate our unwavering support for the Court as an independent and impartial judicial institution. We review our commitment to the Rome Statute and will uphold, defend and promote its principles and values. The atrocities that we continue to witness all around the world and now in Europe as a consequence of Russia's military aggression against Ukraine must strengthen our determination to end impunity for the most serious crimes of concern to the international community as a whole. The European Union and its members and its member states highly value the Court's achievements. All situations where the most serious crimes of concern to the international community appear to have been committed deserve our utmost attention. Now, ongoing investigations cover almost all regions of the world. We are convinced that ICC, in line with the principle of complementarity, will bring justice to victims everywhere. We commend progress made in the review of the International Criminal Court and the Rome Statute system. These important works give us the possibility to strengthen the Rome Statute system and make the court more efficient and effective. We encourage the ICC and state parties to continue engaging in the review and prioritization of the assessment of the recommendations of the independent experts and to continue considering their implementation while preserving the integrity of the Rome Statute and respecting the prosecutorial and judicial independence of the court. We place particular importance on promoting good governance and a healthy work culture that ensures inclusion and gender equality. We underline the importance of equitable geographical distribution as well as representation of the principal legal systems of the world, which all reflects the global nature of the court. The respect and promotion of multilingualism is also essential both for effective communication and the respect of the right to a fair trial. Madam President, the international criminal justice system relies heavily on the cooperation of states. The Rome Statute, in its Chapter 9, imposes obligations for states parties to cooperate with the ICC. We urge all states to lend the necessary assistance to the ICC so that it can carry out its mandate effectively, independently, and impartially. Various forms of voluntary cooperation, such as the relocation of witnesses, enforcement of sentences, and interim and final release of detained persons, are also essential to ensure the efficient functioning of the court. The increase in the court's workload requires increased and sustainable resources. In this respect, we are deeply concerned by the high amount of arrears and late payments to the budget, which significantly endangers the work of the ICC. The court must be resourced sufficiently and on a sustainable basis in order to achieve the purpose and objectives for which it was established. We therefore urge all states parties to provide the ICC with the necessary financial resources and to fulfill their obligation to pay their annual contribution in full and on time. This year, following the request of the ICC prosecutor of 7 March calling for exceptionally voluntary contributions, the European Union and its member states have provided substantial additional financial and operational assistance to the OTP, to the benefit of all situations under investigations or in trial. As the world's first and only permanent international criminal court, the ICC has a vital mandate to hold perpetrators of the most serious crimes to account and to provide justice for victims. The European Union calls on the state parties to contribute to the Trust Fund for Victims, as it plays an essential role in providing justice by ensuring that thousands of victims receive reparations and essential assistance, including physical and psychological rehabilitation and material support. We also urge state parties to support and protect human rights defenders and civil society organizations which relentlessly work to bring justice to victims. Threats and intimidation directed at civil society organizations cooperating with court are unacceptable. Madam President, we believe that efforts to promote the universality of the Rome Statute can contribute to prevention, criminal accountability and justice. The European Union and its member states will continue to advocate for the universal ratification and implementation of the Rome Statute through the various means at their disposal and will continue to work with the international community in a concerted effort to bring constructive and positive attention to the work of the ICC. The European Union urges all countries that have not yet done so to consider acceding to the Rome Statute and to end impunity for the most serious crimes worldwide. It is only by nurturing international law, multilateralism and cooperation that accountability and justice can be assured. We owe it to the victims and to their families, to ourselves and to the generations to come. We have high expectations for the court to deliver justice, and we believe in the integrity of its work in all situations under investigations. I thank you, and Madam President, in addition to the statement I have just made, On behalf of the EU and its member states, I would like to make one brief announcement in my national capacity as the Minister of Foreign Affairs of the Czech Republic. Excellencies, ladies and gentlemen, allow me to use this opportunity to announce that the Czech Republic decided to present the candidacy for a judge of the International Criminal Court at the elections to be held during the 22nd Assembly of States Parties in New York the next year. The candidate is Dr. Pavel Zeman, a former head of the Public Prosecution Service of the Czech Republic. I strongly believe that the high competence of judges is what makes the ICC a trustworthy and efficient court. In this regard, I am convinced that the candidacy of Dr. Zeman will contribute to this task, and I would highly appreciate the valuable support of state parties. I thank you once again.
I thank you for your statement. And now I give the floor to His Excellencies Mr. Wopke Hoekstra, Minister of Foreign Affairs of the Netherlands. Your Excellency, you have the floor.
Thank you, Madam President. Your Excellencies, ladies and gentlemen, let me begin by addressing Mr. Peter Lewis. I'm not sure whether he is in the room, the Register, who has successfully guided the court through some difficult moments throughout the last 5 years. And his mandate expires next year, but I'm sure I'm speaking for many when I say that we're sad to see him go and thank him for his tremendous service. Your Excellencies, after a tragedy, we often say, never forget, or never again. And these phrases express our sense of loss, anger, and of course sorrow. But by themselves, they will not bring justice. And that is why almost 25 years after we created the Rome International Statute, we need to live up to these words every single day again. In 2002, the statute entered into force and created the institution that brings us together today. A court where the worst criminals have to answer for the most egregious crimes. And this year we marked the ICC's 20th anniversary, and we can look back on a number of remarkable successes over the years. The court has firmly established itself as an indispensable pillar in the global fight against impunity. The number of state parties has more than doubled from 60 to 123, and both the number of investigations and their global reach have expanded. International commitment to developing and strengthening the Rome Statute system is growing. Yes, slowly, but also surely. Many state parties have introduced major reforms to their domestic criminal law. And this has significantly improved their ability to try suspects of international crimes in national courts, in line with the principle of complementarity. Next year in Slovenia, we hope to adopt a new convention that will further strengthen international cooperation on the investigation and prosecution of core international crimes. At a time when the most fundamental legal norms are blatantly being violated, most visibly, of course, in Ukraine, these are hopeful steps. But in order to effectively fight impunity, I believe we must take several steps more. The first is to improve cooperation and coordination between the court and state parties. For a start, states should simply promptly execute outstanding arrest warrants. This is, by the way, an obligation under the Rome Statute. Second, states can do more. They can do more to the effective and efficient functioning of the court itself. For instance, by concluding framework agreements to cooperate voluntarily with the court on witness relocation, the transfer of persons upon completion of their sentence, and simply enforcing sentences. And third, state parties must provide the court with an adequate budget and support the courts by paying their own contributions. Ladies and gentlemen, this is the only way. This is the only way to ensure that the ICC can remain financially sustainable and carry out its mandate. The court can count on the unwavering support of the Netherlands. And may I call on all state parties to help the ICC take the next steps on the road to ending impunity. Thank you very much.
I thank His Excellency for his statement, and now I give the floor to the third speaker on our list, His Excellency Mr. Riyad Malki, Minister of Foreign Affairs and Expatriates of the State of Palestine.
Thank you, Madam President. Excellencies, allow me at the outset to commend the President of the ASP, Her Excellency Silvia Fernandez de Gormendi, for conducting the work of the ASP with determination and vision over the past year, and assure her of the State of Palestine's full support. 20 years ago, we established a court with a universal calling. Our court opened its doors to victims of the most serious crimes of concern for the international community as a whole. Never before in history had an effort been made to bring within the scope of one international court a universal response to countless crimes, spanning decades across all continents and building on a century of efforts to develop international criminal law. 20 years ago, justice was no longer a distant hope. It became a recognized right for all peoples that could be realized despite the odds, or so we hoped. Excellencies, justice must be necessarily blind, and so must be the court's application of its mandate. It must be fulfilled effectively and consistently across all situations under its jurisdiction without fear or favor. To this end, we remain concerned about the growing gap in both the resources available to the court and the resources allocated for situations. We are troubled that the court's budget is, inter alia, limiting access of victims to justice and ultimately obstructing the court's mandate. The State of Palestine affirms the importance of substantively increasing the court's regular budget. We also affirm that an equitable allocation of resources is essential to ensure that crimes are prosecuted effectively, expeditiously, and independently across all situations. This is especially pertinent in situations where crimes are ongoing and escalating and where impunity is protracted. The budget of the court and the allocation of its resources could either reinforce selectivity or foster universal accountability. Only a principled approach to ensure long-term and sufficient resources provides the best protection for the court's independence and guarantees a universal, responsive, flexible, and resilient institution. Excellencies, Palestine is a scene of ongoing crimes. In fact, Palestine is the scene. The Office of the Prosecutor recognized this when it opened an investigation in 2021. Undeterred by the court's ongoing investigation, Israeli crimes are escalating and impunity is further entrenching. Yet, the court is still to address this grave situation in the ongoing investigation in Palestine, to honor its mandate and to hold perpetrators of crimes accountable. 2022 has been the deadliest year for the Palestinian people for the last 15 years. It has been a year replete with unabated Israeli crimes, persecution, and an entrenched apartheid serving a settler colonial regime. a year of killing children, demolishing homes and schools, forcible transferring of families, and targeting journalists. Shireen Abu Akleh is another victim of this exceptional impunity that Israel enjoys. The circumstances around her killing are clear, well documented and reported to the court. Yet, not a word and not an action to hold perpetrators accountable. We reiterate that allowing the atrocious assassination of Shireen to go unpunished is to sanction the killing of journalists, and any justice that does not hold Israel's top officials accountable for their crimes is a compromised justice. Excellencies, one could say it's not the court's place to comment on a situation it is investigating. That is valid document or argument if this were true in other investigations. In fact, we see an active court in other situations with an overabundance of statements and declared engagements. Then we have the right to ask why. Why is the situation in Palestine not allocated due attention and resources? Why is the situation characterized by impunity and continued crimes not a top priority for the court? Why is the most documented and protracted situation of crimes and impunity in modern history sidelined and underfunded? Why is access to the court restricted to Palestinian victims when the court's door is wide open to others? Why does this unprecedented scale of Israeli crimes and clear contempt for the law and the court remain unanswered? Why, despite the publication of several damning and highly credible reports by international experts on the commission of crimes under the jurisdiction of the court by Israel, was the court silent? The Palestinian people are entitled to answers. Excellencies, the gravest threat to our court is the criminalization of its work and the escalating attacks against those cooperating with it, including civil society organizations and human rights defenders. As states parties, we have an obligation to stand up for civil society and human rights defenders and to defend their rights to operate freely and independently to help fulfill the mandate of the Rome Statute. In this connection, we reaffirm our unequivocal condemnation and rejection of Israel's criminalization of our civil society and human rights defenders, including raids on their offices, detention, and deportations. I want also to take this opportunity to salute Al-Haq, Al-Damir, Defense for Children International, the Bisan Center, the Union of Palestinian Women's Committees, and the Union of Agriculture Work Committees for their invaluable service to the cause of justice and accountability in Palestine. The State of Palestine calls on the ASP, its presidency, and state parties to defend civil society and human rights defenders, especially those working with the court, including the Palestinian organizations targeted by Israel. We also call on the ASP and state parties to integrate concrete and effective responses to attacks on civil society and human rights defenders into our broader strategies for confronting attacks against the court. We must ensure that civil society's space in Palestine and around the world is protected. This is indispensable to the court's ability to carry out its mandate. Excellencies, the State of Palestine has been consistent and clear in its firm position that accountability for the most serious crimes is essential for the integrity and sustainability of our international law-based order. For the State of Palestine, supporting the court is a commitment born out of principle. This commitment was reflected during our tenure in the Bureau, one of the most active and engaged members in drafting OP1 of the Omnibus resolution in response to threats and attacks against the court, its officials, and those cooperating with it. We have also played a central role in promoting and defending the contribution of civil society and the activation of the court's jurisdiction over the crime of aggression. Not the least, our stance against double standards, delayed justice, selective justice, and denied justice is essential to ensure the sustainability and integrity of the court. Our commitment is unwavering. Justice must prevail. It must be blind. It must be available universally and equally to all. Palestine will not waver or relent until justice becomes a targetable reality. Thank you very much.
I thank you, Your Excellency, for your statement. And now I invite Her Excellency, Ms. Dominique Hassler from Liechtenstein.
Madam President, Excellencies, ladies and gentlemen. The rule of law, international justice and the fight against impunity have been a priority of Liechtenstein's foreign policy for many years. Naturally, the ICC is a focus of our engagement in this respect. The Rome Statute, whose 25th anniversary we will be celebrating next year, has created a powerful system of accountability for the most serious crimes under international law, which places the ICC at its center. The Rome Statute system is based on the primary role of national judicial systems and designed in such a way that the role of the ICC is complementary and one of last resort, where states fail to investigate and prosecute crimes in their national justice systems. A key ingredient of the system is cooperation from state parties, an indispensable element to make the court an effective institution. This cooperation is, of course, essential with respect to the court's investigations and prosecutions, but it extends far beyond that, in particular in the areas of political, diplomatic, and financial support. The annual gathering of this assembly is the place where key decisions in this respect should be made, and we are encouraged by the positive manner in which the court has embraced the recommendations of the independent expert review and the progress we have seen as a result. Steady financial support for the court is essential for its success, as an oversight to ensure the most efficient use of the resources given to it. As a result of the aggression against Ukraine and the numerous crimes we have witnessed in its aftermath, many states have provided massive additional funding to the court, and in particular to the Office of the Prosecutor. Liechtenstein firmly supports the court's investigations in Ukraine and was part of the joint revealer of the situation to the court. At the same time, we also believe that the court's investigations should never be contingent on voluntary contributions from the states, as an important measure to safeguard its independence. This session is the moment for the Assembly to set the court on a steady financial footing far beyond 2023. We can do this by providing the necessary funding for the court's investigations and trial activities, but also by replenishing the contingency fund. This is a key tool to ensure the court's ability to respond to accountability crises with agility, which we certainly all expect the court to be able to do. We are also hoping to see more progress on the universality of the Rome Statute. First and foremost, this means having more states join the Rome Statute and its amendments, as an expression of its increased relevance and political acceptance globally. The most persuasive argument, of course, is an ICC that delivers results in an equitable and truly independent manner. But this also requires the full and equal participations of all parties in the work of the Assembly. This must also include decision-making for the leadership positions in the court. Madam President, Liechtenstein has been a steady and leading advocate for the court's jurisdiction over the crime of aggression. We welcome the recent ratification of the Kampala amendments by Peru, which brings the total of ratifiers to 44. The aggression against Ukraine also requires us to take a fresh look at the court's role on the crime of aggression, given that there has not been a more blatant case of aggression since the creation of the United Nations. The UN General Assembly has determined overwhelmingly that it was an aggression on more than one occasion, and still the court is unable to exercise its jurisdiction due to the narrow jurisdictional regime of the Kampala amendments. We support the ongoing discussions to create a special tribunal to address the aggression against Ukraine. This is a conversation taking place with all UN member states, of course, but it needs to be in sync with our collective decisions as state parties. Ensuring the prosecution of the crime of aggression against Ukraine is also beneficial for the ICC and its central place in the area of international criminal justice. We can ensure this by bringing the jurisdictional regime for the crime of aggression in line with the other three core crimes. The notion that the crime of aggression is a crime that is rarely committed has been proven fundamentally mistaken. It has been replaced by the realization that initiating war is both an assault on the international order and the rule of law as a whole, but also results in the commission of atrocity crimes. The ICC can only effectively play its central role in educating the most serious crimes under international law if it has the competence to do so, equitable and consistently across its full docket of situations and with respect to all four Rome Statute crimes. The ICC carries a very important message, that nobody is above the law, that those who commit the first offenses against international law will be held accountable. This is a uniquely important statement at the time when the international order is questioned and undermined in a systematic manner. And it remains a beacon of hope for the numerous victims of atrocities around the globe. Let us have this on top of our minds, always, and factor in it when making decisions about the future of the ICC. Thank you very much.
I thank you for your statement, and now I invite His Excellency Mr. Makana Ronald Shamukuni, Minister of Justice of Botswana.
Thank you, Madam President, honorable ministers, excellencies, distinguished ladies and gentlemen. Allow me to begin by expressing my delegation's deep appreciation with the excellent manner in which you are guiding our deliberations. We salute you for your outstanding leadership and wisdom and are hopeful that the 21st session will be a resounding success. Madam President, as Botswana, we pledge our full support and cooperation to you and members of your Bureau as you continue to discharge your duties in steering the Assembly of State Parties and the Court to achieve its mandate of attaining justice for victims of serious crime. Over the past 20 years, state parties to the Rome Statute have demonstrated their support to the Court, working together to ensure that the Court upholds universal human rights whilst establishing itself as a cornerstone of international criminal justice. To that end, the Court has successfully delivered justice to victims and ensured global accountability, upholding universal human rights and the rule of law. With our support as members, the Court is able to fully execute its mandate with integrity and efficiency in accordance with the highest standards. This pivotal moment allows state parties to reflect on past achievements and take note of the remarkable role that the court plays in facilitating justice to victims of genocide, war crimes, and crimes against humanity around the world. As we celebrate these achievements, state parties are encouraged to note the obligations to cooperate with the court to enable it to undertake its mandate. Furthermore, we call on all state parties to ensure that the court has the necessary resources to meet its quest for justice now more than ever before. Madam President, it is worthy to note that the activities of the court over the past 20 years have had an enormous impact, not just for individuals prosecuted before the court itself, but for millions of victims, communities, and societies affected by mass atrocity crimes. Through the demonstration of the Trust Fund for Victims and ongoing contribution from state parties, positive impact is made for men, women, and children in affected communities, allowing them to rebuild their lives in a dignified manner. We therefore commend all state parties for their support through contributions made to the Trust Fund for Victims, which helps alleviate the significant suffering caused by horrific acts of violence, and encourage states to make voluntary contributions to the Trust Fund for Victims to ensure that necessary support and reparations are available to those who need this support most. Madam President, Botswana strongly believes that the International Criminal Court embodies a truly progressive multilateral system that 20 years on continues to make concrete impact against impunity. Current geopolitical issues remind us that it is imperative that all state parties stand firmly together in our collective efforts to deliver justice for alleged international crimes. It is our shared responsibility to tirelessly support and take decisive and concrete action to ensure that the Rome Statute becomes a universal legislation through an increase in the number of countries that domesticate the statute. We therefore encourage all countries to become state parties to the Rome Statute and urge those that have signed to proceed to conclude the ratification process. The role of the International Criminal Court is pivotal in that it is a universal system that brings justice to those who need it. Therefore, the court requires our full support, particularly now in the ever-evolving international criminal justice system. This assembly and the 20th year commemoration present a moment of reflection and a further opportunity to recommit to the Rome Statute. Let us continue to demonstrate our support for the court and work together as state parties to ensure that the court delivers justice for all. In conclusion, I wish to reaffirm Botswana's commitment and support to the ICC in the execution of its critical mandate. I thank you for your kind attention.
I thank you for your statement, and now I invite His Excellency Mr. Abubakar Malami-San, Attorney General and Minister of Justice of Nigeria.
Madam President, Assembly of State Parties, on behalf of the government and the people of the Federal Republic of Nigeria, I would like to commend you for your exemplary leadership and dedication in conducting the affairs of this session and for the efforts that are put in place to ensure a hitch-free 21st session of this Assembly. We also extend our congratulatory message to the leadership of the Court and the Bureau for the tremendous contributions towards successful organizations of this gathering. I would like to use this opportunity to reiterate the importance of the Rome Statute in combating heinous crimes as perpetrators of crimes that shock the conscience of humanity must be held accountable. Nigeria's strong belief in the dreams of the founding fathers of the Rome Statute and its desire to join other like-minded state parties at putting an end to impunities informed its decision to accede to the statutes. Nigeria is also committed to the domestication of the Rome Statute, and the National Assembly of Nigeria is working assiduously with the office, with my office, the Office of the Attorney General, to achieve this. As disclosed in our previous statements, Nigeria firmly believes in the rule of law as a panacea to a just and equitable world. Consequently, our nation has contributed to uphold her obligations under international law. With regards to the ongoing preliminary investigations in Nigeria, the federal government has not reneged in its pledge to extend maximum cooperation to the office of the prosecutor of the court in addressing the allegations of crimes against humanity committed within its territory. There has been increased exchange of correspondence between the federal government of Nigeria and the office of the prosecutor, and Nigeria has appointed a focal point specifically designated to respond to all requests bordering on criminal law and prosecution issues. This has aided the seamless interactions between Nigeria, the analysts, and the international cooperation advisors of the OTP. The cooperation extended to the court culminated in the first official visit of the prosecutor and his team to Nigeria in April 2022, during which he discussed the subject with His Excellency President Muhammadu Buhari, GCFR, the Vice President, HE Professor Yemi Osinbajo, and other senior government officials in Nigeria. Nigeria is currently working on a memorandum of understanding with the Office of the Prosecutor with a view to galvanizing regional support and buy-in of the continent for the ICC. This is further consolidated by the policies put in place, inclusive of enhancing the capacity of the armed forces on Rome statutes and de-radicalization. The military is equally working on serious crime response team over and above efforts being made to enhance the efficiency of the court-martial arrangement backed by legislation. I take this opportunity to reiterate the fact that Nigeria will continue to demonstrate strong political will to hold perpetrators of terrorism and the heinous crimes accountable, in line with our firm belief that protection of fundamental rights of victims of crimes against humanity are not negotiable. Nigeria believes in the principle of complementarity and will continue to play a leading role in ensuring that perpetrators of crimes against humanity are prosecuted and victims get desired justice. Madam President, my delegation specifically commends this Assembly for the measures taken to strengthen the court systems, most especially as it currently assessing the recommendation of the group of independent experts. These noble steps are highly commendable, with the quality of leadership of the court, coupled with the assessment carried out so far. The world is anxiously waiting to see a new court system that will be acceptable to all. If we are indeed to rid the world of the impunities, a strong and stable international criminal court system is not negotiable. In recent times, we have observed that the budget of the court has continued to increase in view of the prevailing inflation around the world. The economies of most state parties are just recovering from the impact of COVID. there is need for the court to be more innovative in carrying out its assigned mandate in an efficient and effective manner. As we call for timely implementation of the recommendations of the IER for maximum performance of the court, Nigeria believes that prioritization of the implementation of the recommendation will ease financial burden of the court. As a country, we remain committed and have indeed been up to date in keeping to our financial obligations and make advanced payments and not in any areas as far as financial obligations are concerned. In view of the fact that this is the last Assembly of State Parties that Mr. Peter Lewis will participate as the Registrar of the Court, permit me to congratulate him in advance for his service and contributions to the reformation of the court. We hope the best and most qualified candidates will be elected to replace him. We would like to also extend our congratulatory message to the ongoing members of the Committee on Budget and Finance for their good work and wish them well in their future undertakings too. In the like manner, my delegation congratulates the new members of the Committee on Budget and Finance and believe that they will sustain the successes recorded by these distinguished outgoing members. My delegation will continue to advocate for the need to elect the best and most qualified candidates for various positions in the court. I thank you most sincerely.
I thank you for your statement, and now I give the floor to His Excellency, Mr. Álvaro Leiva Durán, Minister of Foreign Affairs of Colombia.
Good afternoon. Presidenta.
Madam President, I'll be speaking in Spanish. Assembly, Madam President, and all of those here in attendance, all of the participants in the ICC and the Rome Statutes system, and you, President Celia Fernandez Urmendi. This is the third time that I've come to the International Criminal Court. The first time was in the 13th of August, 2018. We were under an preliminary examination, and that had started 17 years prior to that. And I came as part of a justice commission that was set up because of the peace missions that followed the talks that took place in Cuba between 2012 and 2016 between the government of Colombia and the FARC-EP. And the mandate was to establish procedures that would make it possible for us to come up with a special jurisdiction for peace. That was my mandate, and there were 6 people in my team. And we came for the agreement and signing it and accrediting it before the ICC. And that is what I've done on previous occasions. Now, we required a special jurisdiction because it was established that the state was a party to the conflict, either through action or omission, and therefore it was important to come up with a special formula that was tricky to come up with. We worked with the UN, working on international humanitarian law, human rights law, international law, the basic customary law, and, of course, the Rome Statute. Naturally, we wanted to make our own comments, the 3 of us who came here. And as I said, 3 of us were on the commission itself. And what we stated were some basic facts, trying to get cracking, right? Because here time is of the essence. And so what is the agreement all about? Well, it said that the main function and component of justice was be implemented simultaneously and holistically to all those who either were involved directly or indirectly in the armed conflict. And its decisions, there would be judicial guarantees to all of those coming forward, be they combatants or not, who were tied to this conflict. And at that time, the conflict had been going on for 60 years, so you can imagine. And of course, we also stipulated that any acts under the judicial authorities in these special jurisdictions shall see their rights respected of due process, defense, presumption of innocence, and the independence and impartiality of the judges in the various chambers, as well as those of the investigation and prosecution side. So we had a special jurisdiction for peace, and it would all be based on the principle of favorable rulings in all of its actions, and in particular when it comes to the treatment who comes under the jurisdiction of the special jurisdiction. And so this was when we introduced the national margin of appreciation notion, taking in time of all of the conflicts, the specific circumstances. We're talking about 60 years of conflict. So we felt it necessary to make some observations when we came. And so I came back with two other people, including Dr. Danilo Rueda, who today is the High Commissioner for Peace, that we are continuing to push forward as part of what we call total peace. And it all begins with the Liberal Army of Liberation. And so we made some observations, and of course I can't go into all the details here today, but the High Tribunal, the High Constitutional Tribunal, and this setting aside all of the agreements between the national government and FARC, third-party civilians who were not combatants, who were involved in illegal activities associated with crimes against humanity or war crimes under the Rome Statute, should only come before tribunals in this special jurisdiction. And that was repealed. It was stated that thereafter they could come voluntarily to the jurisdiction, provided that the ordinary jurisdiction had looked into the things and investigated things first, because we saw that there was a loophole, and we wanted to make sure that we wouldn't jeopardize everything that we're trying to do. This, nonetheless, could have an impact on victims' rights, especially given the fact that the preamble of the Rome Statute itself states in its second whereas that the state's party are aware of the fact that over the century, millions of men, women, and children have been victims of atrocities that boggle the mind and that shake people's humane conscience to the core. And then, again, I would like to refer to the victims and what is stated in Article 15.3, for example, or 19.3, or 40.6, or 54.13b, Article 63b, 74.2, Article 65.4, 68.123, 75.1234, and many other articles refer to this. So in our case, this was something that was going to hold us back for a long time. And so what we needed to do was to draw the International Criminal Court's attention to the fact that it could be aware of the situation and be on the alert in case it was necessary for them to refer something to the Special Jurisdiction for Peace. We also made observations that I would like to share with you this afternoon. And that was the fact that the Rome Statute is quite clear in Article 120, where it stipulates reservations and says that no reservations can be entered to this statute. And what this means is that there cannot be a unilateral alteration of any parties to any of the articles contained therein. And when it comes to our national legislation, some people have tried to sidestep Article 27 when it comes to procedural reasons. And what it says is that the present statute shall be applied equally to all cases, regardless of their official capacity or not. The official capacity of a person, be he or she a head of state or government, a member of a government or the parliament, a representative who's elected by the people, or a state official, no person can shirk or escape judicial culpability and accountability or constitute grounds for a reduction of the sentence. And secondly, the formalities and procedures that are exercised regardless of somebody's official capacity in national law or international law shall not stand in the way of the court having jurisdiction in the matter. Now, I wanted to just focus on this because in Colombia, when it comes to Article 27, some people have tried to sidestep it a bit. And then lastly, I would like to stress the following. Jus causis. Just cauius. In Colombia, this is extremely important. The treaty on treaties, the law of treaties in Vienna, and talks about jus cautis. Well, there are rights that are emerging day in, day out because of these conflicts, and because of the need to refer to international bodies to resolve disputes that have to do with jus cauius. And I state this simply so that we should all have it in mind, that we shouldn't forget the fact that it's because of these institutions that give rise to rights. So again, I would just like to drive this point home, even if you are all familiar with this, but it's something that applies to everything that you might see in Colombia, which means unshakable general principles of international law that are at the summit of the international legal order that trump any other standard that may be raised against them, be it through custom or through convention. And as an Argentinian writer said, and I will paraphrase here, proactive right, compulsory right, imperative right, absolute right, peremptory right, conclusive right, inalienable, immutable, something that is fully applied that protects the social well-being of a given community. Now, when you've been a negotiator, such as I, with groups in all sectors, even those who've been taking up arms since 1984, I've been involved in this, the one thing I can say is that this right to build peace and to usher in total peace, you have to go weaving it as you go along. It has to be something that grows every day so that the planet can be completely different. Thank you very much.
Muchas gracias por su.
Thank you very much for that statement.
The floor to His Excellency, Mr. Alphonse Charles Wright, Garde des Sceaux and Minister of Justice and Human Rights of Guinea.
Merci, Madame la.
Thank you, Madam President. Dear distinguished delegates, ladies and gentlemen, it's for me and my accompanying delegation an honor and a privilege to take part in this 21st session of the Assembly of States Parties to the Statute of Rome. Our presence here at this important event is the proof of the will of the government of the Republic of Guinea under the leadership of Colonel Mamadi Doumbouya, President of the Transitional Government and Head of State, to work alongside all nations who cherish peace and justice and who are engaged in the struggle against impunity. That is why I should like to make the most of my time here at this lectern to transmit to you the warmest salutations from Mr. Colonel Mamadi Doumbouya, President of the Transitional Government and Head of State of my country, whose vision dovetails perfectly with the expressed missions of the ICC, namely to continuously and tirelessly work to combat any actions that dehumanize and that undermine the supremacy of the human being, such as genocides, war crimes, crimes against humanity, etc. This convergence of point of view between the government of the Republic of Guinea and the ICC should lead us to further deepen our reflections on the emergence of a world focused on the principle of responsibility for one's acts vis-à-vis others. The sessions of the ASP for states that are party to the Rome Statute is the ideal framework in which to hold such exchanges and reflections, particularly when it comes to this principle of responsibility from one's actions. Madam President, ladies and gentlemen, this assembly is being held at a very particular juncture for my country, as engaged as it is in an irreversible process of overhauling the state and institutional rectification, a process which got underway on the 5th of September 2021. It's a process which has at its very heart justice, human rights, reconciliation, and above all, the fight against impunity. Indeed, the socio-political situation in the Republic of Guinea, which has been inherited by the new authorities, has been marked by numerous flaws, such as corruption, poor governance, politicization of administration, and the instrumentalization of justice. And all of these practices were fostered by rampant impunity. And that is why overturning this trend that the government is now committed to through its decisive actions, and in particular the struggle against economic crimes and war and serious violations of human rights, is of such importance. Madam President, ladies and gentlemen, so talking about serious violations of human rights in Guinea reminds us of the universal consciousness of the events that took place in Conakry on the 28th of September 2009 in the stadium of Conakry. Indeed, Guinea was sadly in the spotlight that day because of the repression of the authorities at the time, where a peaceful manifestation, a peaceful protest by citizens who were exercising their basic right, guaranteed by international rights and the protection of human rights, was violated. At the time of those tragic events, 156 people lost their lives, about 100 women violated and raped, and many people that went missing. Others were seriously injured, and some are still suffering the consequences of it today. And since then, the victims, their beneficiaries, the people of Guinea and humanity in its entirety have been waiting for justice to be delivered. And believe me, the government now will not let such actions go unpunished. And that is why since taking power on the 5th of September 2021, Colonel Mamadi Doumbouya, President of the Transitional Government and Head of State, has decided to bring those the perpetrators responsible for these atrocities to trial. And it's in order to operationalize this will that we took such measures to ensure that this trial could be held, so as to turn the page on this dark page of my country's history. And it was thanks to this personal commitment from the President of the Transitional Government that we declared on the 12th of September 2022 at the 51st session of the Human Rights Council in Geneva that the Transitional Government would respect its main commitments to the people of Guinea and the international community, and that is organize a trial for the events of the 28th of September 2009. And I'm delighted and proud to say that since the 28th of September of this year, the alleged perpetrators, including the head of state at the time, are to be brought before the Criminal Tribunal of Dixin with the respect of rights of all parties. Madam President, ladies and gentlemen, this is a time to extend our sincere thanks on behalf of the President of the Transitional Government and of the Government of the Republic of Guinea, to thank the International Criminal Court for its interest and support in bringing about this trial. In fact, ever since these events, the ICC has never wavered in its encouragement to Guinea for taking the most appropriate measures so that these heinous crimes would not go unpunished and that justice could be given to victims. And it was in the framework of the OTP that many missions to Guinea were carried out so as to move the case forward. And Colonel Mamadi Doumbouya gave a new dynamic to the relations between Guinea and the ICC in order to finalize this thorny file. And so it was that on the 28th of September of this year, the trial for these painful events was officially launched in presence of all of the partners in Guinea. And on that occasion, a memorandum was signed between our president, the president of the Transitional Government, and the prosecutor of the ICC. And in this case, enhancing the complementarity and cooperation between the Republic of Guinea and the Office of the Prosecutor of the ICC. The signing of this agreement enabled Guinea to underscore its determination to respect its international engagements and to play its role in moving towards a world without impunity. That the United Nations, through the ICC, found was able to achieve this with us, I think deserves all the gratitude of my government and of the people of Guinea. The holding of a trial of this magnitude has been a very costly process for a country that is engaged in the process that it is of overhauling the state and modernizing its institute and rectifying its institutional fabric. And yet, considerable efforts have been undertaken, particularly when it comes to the material organization of the court, as well as in the framework of reparations and indemnities for victims. So the government has taken measures for the construction and outfitting of a new courthouse, the promulgation of laws concerning the protection of victims, witnesses, and people at risk, and a fund for victim indemnities. The creation of this reparations fund hopes to assist victims and their families to rebuild their lives. However, because of the international economic crisis, the government of the Republic of Guinea is requesting support from the international community so as to put this ambitious reparations program into practice. Madam President, ladies and gentlemen, the government of the Republic of Guinea, faithful to its commitments to sustainably install in the country a process of democratic construction based on the respect for human rights, is ever ready to closely cooperate with the ICC so as to bring this trial to its logical conclusion. And it also has the commitment to ensure that no perpetrator of such atrocities can get away with impunity. So on behalf of my government, the government of the transition, and Colonel Mamadi Doumbouya, we thank you.
I invite Her Excellency Ms. Anniken Huitfeldt, Minister of Foreign Affairs of Norway.
Madam President, it's a great privilege to address this assembly on behalf of Norway. Norway is a steadfast and strong supporter of the ICC. We remain committed to defending the court from any attempts to undermine it. We have supported and will continue to support the court in all relevant forums, as we have done in our capacity as an elected member of the Security Council over the last 2 years. Norway sees the ICC as a beacon of justice in the world, stepping in when other mechanisms fail. A culture of impunity fuels conflict. Accountability, justice, and the protection of civilians are crucial to promote long-term international peace and security. Over the last year, the court has faced an exceptional situation with a record workload. I would like to express my sincere gratitude to the court's officials and staff for tackling this situation with determination and professionalism. Earlier this year, Norway joined more than 40 other countries in referring the situation in Ukraine to the court. We are pleased that the ICC is investigating possible war crimes and crimes against humanity in Ukraine. Those who commit atrocities must know that their actions will never be forgotten. War crimes will be investigated, and individuals at all levels must be held accountable for their actions. The ICC's mission remains as crucial as ever, both in the context of Ukraine and globally. Madam President, Norway seeks to promote a strong, effective, and independent court. The review process is of paramount importance in achieving this goal. Now we are nearing the end of the assessment phase. We must stay the course and deliver on implementation. And this must be done efficiently, with a focus on results. So far, we have only seen the beginning of a process. Genuine follow-ups is vital. Moving forward, Norway will continue to give priority to improving the governance of the court. A healthy working culture, gender equality, and integrity are essential to maintain productivity, efficient operations, and the ICC's reputation. This is especially important now that the court is facing an unprecedented number of open investigations. Sound management is key to the court's success in this situation. Madam President, in order to carry out its mission, the court needs to be properly funded. All states parties must live up to our responsibilities and ensure that the court has the resources it needs to meet our increased demands. At the same time, the court must ensure its own effective and efficient function. Let me close by reiterating Norway's strong commitment to the ICC. We look forward to productive discussions on how to strengthen the court and the Rome Statute system. Thank you.
I thank Her Excellency and invite Her Excellency Ms. Antonia Urrejola Noguera, Minister of Foreign Affairs of Chile.
I'm delighted to address the ASP, and we send our special thanks to Madam President Silvia Fernandez de Gurmendi, as well as to the Secretariat. From the outset of the process that led to the creation of the ICC, Chile has always lent its firm support to the Rome Statute and its mandate to end impunity. Indeed, in Chile, on the 11th of September 98, on its anniversary, in fact, of its coup d'etat, that it ratified the Rome Statute. This really was a turning point in our in our history when we were able to ensure complementarity between the different aspects of legislation and ensure that impunity was no longer possible. Now it's been 20 years since the Rome Statute came into effect, and the ICC that is now bringing to justice some of the perpetrators of the world's most heinous crimes, and it's also set up effective reparations measures for victims. In fulfilling its mandate, it's important that it has support from its member states, that it's important for it to have not only economic resources, but also significant cooperation for sentence enforcement and witness relocation, arrest warrants, etc. The very first trial at the ICC was able to brought to justice a perpetrator of crimes against women and accused of gender crimes, was another milestone for the court. And now we see that the Darfur case is underway. And given this context, Chile is watching with great interest all of the pre-trial cases and all of the situations that are currently under investigation. When we look at the situation in Afghanistan and the lack of protection for its inhabitants, particularly for women and girls, we think that this is a particularly worrying situation. And we hope that the ICC will be able to take action in this regard, and in this case, build to serve to protect victims. These 20 years have enabled the court to become stronger, and while at the same time we celebrate the milestones, we also need to acknowledge how very much needs to be done, and we should never sit on our laurels and think that the work is done. It is important that the court becomes ever stronger with all of our support if we really are to make a difference, which means a greater efficiency, a better support from the states parties to the statute, and to ensure true independence in its workings. That is why we think that boosting the complementarity mechanism, which is one of the key aspects of relation between national legislation and the court, is of such importance. But for that to occur, it's the states parties themselves that need to make sure that they keep in their own internal legislation working, keep their efforts up. We'd like to extend our acknowledgement to the court that the court is not here to undermine any national legislation, but au contraire is here to strengthen the state's ability to exercise their sovereign powers to prosecute heinous crimes. The phenomenon of a positive complementarity, which was so vital for developing local legislation and judicial processes, is another key aspect. Analysis of complementarity is especially important when you see that a preliminary investigation or a situation is opened. It's important for the court to have the wherewithal to do this. But the relevance of complementarity goes further. There are a whole myriad measures in local domestic legislation that can fight against such crises, or if in the case that such alleged crimes have been committed, it enables another toolbox for investigating and prosecuting them. It's important to cooperate not only with the court, but also to state with other states and also with civil society and with victims' organizations and representatives, so that these crimes can finally be can finally be brought to justice. It's important also to make sure that if there is a lack of will or a lack of tools to bring perpetrators to justice in a local context, to use these various measures to boost greater access to justice for one and all. States can expect that this cooperation with the ICC can bring all kinds of benefits, not only for jurisdictions as they stand, but for the future direction of the development of the judicial process. Chile is confident that the court will continue to grow stronger, and at the same time is very aware that the commitment of one and all to making this a success is possible. And so, given our unwavering commitment to humanitarian law and the upholding of human rights, the government of Chile would like to re-express the importance it places on the support for the ICC. On the 2nd of March last year, a man. Recently, there was a statement made concerning upholding the need to bring to justice those who have committed crimes, and this is something that we're going to be bearing in mind, in particular, given the very worrying situation in Ukraine. It's important for the court to retain its impartiality, and for this to occur, we believe that any crimes committed under its remit need to be investigated wherever they are. And this also means that it's important to equip the court with everything it needs to investigate crimes wherever they are, and this means protecting witnesses wherever they are. And that the work being done is purely judicial in nature, and politics needs to be left out of such processes. Chile recognizes the importance of this in the struggle against impunity, and that is why we are calling for the protection of civil society, in particular those who cooperate with the court, and for rejecting any violence shown against those who cooperate with the court. Operations of the court need to be maintained despite all of the cost of living crisis that everyone is experiencing around the world, and that is why Chile believes that it's so important to maintain or to honor our commitments financially when it comes to the court by paying our contributions on time and in full. If without this wherewithal, the court will not be truly independent and able to fulfill its mandate. We reiterate our commitment to the court, remembering that from here on we need to further strengthen its mandate, to further consolidate the milestones that it has achieved, particularly given the worrying situations in many parts around the world. It's undeniable that cooperation between the court and its states parties is of vital importance if we're to move forward together. And not only will this send a strong message about ending impunity, but it will contribute to building peace and security throughout the world. Every time the court arrives at another milestone, then we're making the world a better place to live. As we've already heard, that Justice is the best way to bring about a more humane world. We are talking about a very basic human rights, the rights to justice, the right to live in a world of peace, and the right to due process. We trust in the Rome Statute and the functions of the court to contribute to this process. And we call on those who are not yet states party to the Rome Statute to ratify swiftly. Thank you very much.
And now
Thank you.
His Excellency, Mr. Jean Asselborn, Minister of Foreign and European Affairs of Luxembourg.
Madame la Présidente de l'Assemblée,
Madam President of the Assembly, ladies and gentlemen, Luxembourg associates itself fully with the declaration read out by the European Union. Since the signing of the Rome Statute, Luxembourg has been a strong defender of the ICC and the fight against impunity. I would like to commend the staff of the court for the efforts that it has made over the past year and reiterate my country's staunch support. I would also like to take this opportunity to thank the Registrar, Peter Lewis, for all of the service that he provided to the ICC. I would like to express to him my great gratitude for his tireless efforts to ensure that the court operates properly. This year is the 20th anniversary of the entry into force of the Rome Statute, and this gives us the opportunity to pay tribute to the court, as well as to all of those who have turned the ICC into an independent, impartial institution based on the principles and values of international criminal justice. The court has weathered many challenges with resilience and perseverance. It's adapted to changes and has managed to resist any attempts to deviate it from its role and its legitimacy. The support of states parties to the ICC remains of paramount importance, and my country is determined to continue providing its support to the court in our collective battle against impunity. I would like to take this opportunity to encourage all states to ratify all of the amendments of the Rome Statute, including the Kampala amendments on the crime of aggression, and including the recent amendment which would say that deliberately starving civilians as a weapon of war is a war crime. And this is something that the court has jurisdiction over for armed conflicts that are not of an international nature. Ladies and gentlemen, the atrocities that we've seen around the world and that we see right now in Europe following the military aggression of Russia against Ukraine should steal all of our determination to put an end to impunity. Unfortunately, new atrocities are being committed, and the role of the court, therefore, is more essential than ever in order to make sure that victims see justice. Luxembourg welcomes the decision of Prosecutor Khan to open an investigation into the situation in Ukraine, and we are committed to supporting the work of the court so that those responsible for crimes are brought to account. At the same time, it's important not to overlook other areas where serious crimes of concern to the international community are being committed. And all of these situations require our greatest attention. The investigations currently underway cover practically all regions of the world. The rising number of ICC investigations reflects a deeper reality, and that is the workload of the court, which is higher than ever. For the court to be able to continue to match our expectations, and in particular the hopes and expectations of victims, it's important for the court to have lasting, sustained financial resources that need to be revised upwards. Luxembourg is one of the many countries that have made a special voluntary donation to these that was set up by Prosecutor Khan. Now, even though the situation is exceptional, the ICC cannot function on voluntary contributions alone. Such an approach would not only jeopardize the sustainability of the budget, but also its independence. I'm aware of the fact we face many challenges when it comes to the budget, but the court needs more resources now than in the past in order to carry out its mandate and to be more resilient in an international context that's constantly changing. Financing of the court cannot be done to the detriment of international justice and the victims of the most serious crimes. Again, I would say that Luxembourg is formally opposed to a zero nominal growth budget for the ICC. I would reiterate my appeal to all states parties to pay their annual contributions in their entirety and within the stated deadlines. Unfortunately, the amount of arrears has not gone down. This might lead to liquidity crises for the court. Paying one's contributions is an obligation for all states parties, and by respecting that obligation, they reflect their own commitment to fighting against impunity. I welcome the work that's going on as part of the review mechanism. This gives the court an opportunity to make all of its work more effective in order to provide justice to victims all around the world. Last year, I launched an appeal for the promotion of a better culture of work, and I can see that there is a new informal mechanism and changes in the Code of Ethics have been adopted. Luxembourg welcomes these developments and would encourage all stakeholders to remain involved in this very productive process, while at the same time upholding the integrity of the Rome Statute and in full respect of the independence of the court. Respect and promotion of multilingualism are also essential for effective communication and the respect for a fair trial. Ladies and gentlemen, Luxembourg sets great store by justice for children. However, we note that some the sensitive perspectives of children are not necessarily mainstreamed into international judiciary mechanisms or even at national level. And so we must deploy greater efforts to provide political and financial support for a greater hierarchization and visibility of violations and crimes committed against children. Together with the court, we must provide ourselves with the wherewithal to acquire specific expertise in the area of children and have better exchanges of best practices so that children receive the special attention that they are due throughout the entire judiciary process. I would like to take this opportunity to confirm Luxembourg's continuous support for the Trust Fund for Victims and the Special Fund for Witnesses. Madam President, the Rome Statute is based on complementarity. The corollary to this is cooperation as a tool to achieving international criminal justice. States parties are under the obligation to cooperate with the ICC, and I would urge all states to lend requisite assistance to the court so that it can carry out its mandate in an effective, independent, and impartial manner. It's only through cooperation that multilateralism and respect of international law that accountability and justice may be guaranteed. Over the coming days, let us follow the imperative of justice and not forget those who are at the heart of our discussions, to wit, the victims. I will assure you of my delegation's tireless support for this. Thank you. I thank you, Your Excellency, for that statement.
His Excellency, Mr. Pekka Haavisto, Minister for Foreign Affairs of Finland.
Madam President, Finland aligns itself with the statement delivered today on behalf of the European Union. I thank you, the President and the judges, the prosecutor and his deputies, for your efforts to advance international criminal justice and strengthen the Rome Statute system. My special thanks to Registrar Mr. Levis for his dedication and outstanding performance as his term of office approaches its end. This year marks the 20th anniversary of the ICC. As the court has reached maturity, we see the full scale of its operations, from preliminary examinations to the implementation of repatriation orders. For 2 decades, the ICC has been a beacon of accountability, leading our efforts to curb impunity for the most serious crimes of concern to the international community as a whole. The ICC remains as important as ever, given the atrocities that unfold in many parts of the world today. The opening of a full investigation in the situation of Ukraine and the crimes that continue to take place there is one stark reminder of this reality. Madam President, the ICC is a court with a global mandate, but also a court of last resort. The ICC does not replace national judicial systems, but strengthens and complements them. The ICC only steps in when necessary. The universality of the Rome Statute remains a central priority as it fosters the worldwide ecosystem of accountability. To deliver on its promise and mandate, the court needs resources that match its workload. Exceptional voluntary resources can support but not replace sustainable resourcing through the regular budget. All states parties have a legal obligation to pay their contributions in full and on time. Delaying justice is not an option. We created the ICC to serve many purposes, from combating impunity to contributing to sustainable peace. At the heart of the Rome Statute system was always the promise to focus on the victims. To ensure we hear their voices through meaningful participation and provide assistance and repatriation for the unfathomable suffering they have endured. In most cases, the ICC fully relies on the Trust Fund for Victims. Finland is a long-standing contributor to the Trust Fund, and I call on others to join us. Madam President, the ICC still faces opposition and attempts to undermine its work and legitimacy. I reinstate Finland's unwavering commitment to the independence and the impartiality of the ICC. The court deserves our political and financial support, as well as cooperation essential for its functioning. As we support and protect the ICC itself, we must also do the same for those who collaborate with the court. Human rights defenders and civil society actors around the world are often on the front line, gathering evidence on violations of international law, and too often harassed and intimidated to prevent them from providing their findings to the attention of the ICC. Madam President, amidst the challenges of pandemic recovery, combined with the economic instability and food crisis caused by Russia's unlawful invasion in Ukraine, we cannot forget the existential threats posed by climate change and biodiversity loss. I welcome every effort to use international criminal justice to respond to these threats. In this regard, I would like to highlight the International Law Commission's draft principles on protection of the environment in relation to armed conflicts, commended this year by the UN General Assembly. This assembly also allows us to continue discussions on the Ecocide initiative. I thank you, Madam President.
I thank His Excellency for his statement, and I invite His Excellency Mr. Alexander Schallenberg from Austria.
Madam President, Excellencies, ladies and gentlemen. On the 24th of February, war has returned to Europe. Russia's aggression against Ukraine is not only causing unspeakable human suffering, it is also a direct assault against the rules-based international order and the very principles of the UN Charter. Russia is directly targeting civilians. Missiles and drones are used to destroy water, electricity, and heating infrastructure. The goal is as simple as it is cynical: to cause terror among the Ukrainian population. The UN Commission of Inquiry has confirmed that war crimes and grave violations of international humanitarian law have been committed in Ukraine, and that Russian armed forces are responsible for the vast majority of them. The pictures of Bucha and other towns will forever be engraved in our collective memory. One thing is crystal clear for me: the perpetrators must be held accountable. I'm therefore proud that Vienna is host to the UN Commission of Inquiry on Ukraine, that we train and equip Ukrainian war crime investigators, and that we actively support the efforts by the International Criminal Court. However, we all know that sadly Ukraine is not the only hotspot. Crimes against humanity and war crimes are continuing and even intensifying in other conflict areas. With 4 ongoing trials and investigations in 16 situations on 4 continents, the court is more in demand than ever before. We commend the court's progress on Darfur. However, we regret that former head of state al-Bashir has still not been transferred to The Hague. On Afghanistan, Austria welcomes the court's decision to resume investigations. The Taliban want to drag the Afghan society back into the Middle Ages by excluding women and girls from most aspects of public life. And it remains deeply frustrating that situations such as in Syria, Iraq, or Yemen continue to be outside of the ICC's jurisdiction. Ladies and gentlemen, more than ever, we need to stand up for the universality of the Rome Statute. Therefore, Austria has further stepped up its support for the ICC. We seconded an expert to the Office of the Prosecutor, and we provided an additional voluntary financial contribution. A further financial contribution is on its way and will be announced shortly. Furthermore, we doubled our payments to the Trust Fund for Victims, and we contributed to the Trust Fund for Family Visits. Ladies and gentlemen, no man-made institution is perfect, and the ICC is no exception. It must continue to improve its efficiency and implement reforms. But let us not forget the reason for which the court was created: to fight for international justice, to hold those who commit crimes against humanity accountable, and to strengthen the rule of law. This is indeed a challenging task. For justice to prevail, we need patience and endurance. I can assure you that Austria will continue to do its utmost to assist the court in realizing its mission, which is so essential to all of us. Thank you.
I thank His Excellency, and now I invite Her Excellency Ms. Nanaya Mauta from New Zealand.
E ngā mana, e ngā reo, tēnā koutou katoa. Madam President, Excellencies, distinguished delegates and friends, greetings from Aotearoa, New Zealand. I welcome this opportunity to reaffirm our long-standing support for the International Criminal Court. As we celebrate 20 years since the Rome Statute came into force, global challenges have illustrated just how critical the court's role is. We believe the court is a central pillar in the international rules-based order, and that it ensures accountability for the most serious crimes. New Zealand's long-standing support for the ICC is a reflection of the values we uphold and how we seek to assert what we stand for. That's why I'm proud that we came forward as one of the group of countries to formally refer the Ukraine situation to the court. We've been unequivocal in choosing to stand firm with those who share our commitment to the international rule of law, accountability and justice. With the ICC facing an unprecedented workload, New Zealand is focused on ensuring the court is sufficiently resourced so it can continue undertaking its investigations and prosecutions independently and impartially. As part of our support, we've provided additional funding this year and deployed a specialised national expert to work with the court. Alongside these actions, New Zealand supports a regular budget that is reasonable and justified and allows the court to fully implement its mandate. We thank the Committee of Budget and Finance for its guidance in the lead-up to this year's Assembly. Once the budget is agreed, we are committed to paying our contributions in full and on time, and call on other state parties to do the same. New Zealand also acknowledges the important work of the Trust Fund for Victims to provide reparations and assistance to those who have been harmed. I would like to encourage other parties to consider supporting the Trust Fund for Victims through voluntary contributions. I would also like to thank the Registrar, Mr. Peter Lewis, for his years of service and his ability to lead the court in a cooperative, principled and steadfast manner. As we celebrate the court's many accomplishments over the past 2 decades, it's important that we look ahead to the next chapter. New Zealand will continue to support the ongoing review process to strengthen the Rome Statute system and enhance the effective performance of the court's mandate. We look forward to the positive changes implementation will bring, including on gender equality and geographic representation, which will need to be carried forward by all parts of the court and by state parties. Madam President, New Zealand takes this opportunity to note our support for future discussions around the concept of ecocide as an international crime to address environmental destruction at a global level. The Office of the Prosecutor plays a critical role in the effective functioning of the Rome Statute system, and as such, we would like to acknowledge the Office for their dedicated work and service to the court and its mandate this past year. New Zealand encourages parties that have not done so to consider incorporating Rome Statute crimes and principles into their domestic law, and we reiterate our unwavering support for the International Criminal Court and the Rome Statute system. Thank you, Madam President. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa.
I thank Her Excellency, and now I invite His Excellency Mr. Zbigniew Rau, Minister of Foreign Affairs of Poland.
Madam President, Excellencies, distinguished delegates, let me begin by expressing my sincere gratitude to the President of the Assembly, the President of the Court, and the Prosecutor for their efforts over the past year. Special thanks go to the outgoing Registrar, Mr. Peter Lewis, for his excellent work during a difficult period. The task for Mr. Lewis's successor will be no easier. And whoever they may be, I hope that he or she will manage the court's operations with equal efficiency while enjoying the trust and support of the state's parties. Madam President, hopes placed in the International Criminal Court have never been so high. Certainly, that is the case for Poland, and I believe it applies to the rest of the world as well. Russia's invasion of Ukraine has unleashed the first full-scale war on the European continent since World War II, with atrocities being committed on a vast scale. As Ukraine's neighbor, Poland feels the war's horrors and the effects on its victims with a special intensity. If the declaration in the Rome Statute that the most serious crimes to the international community must not go unpunished is not an empty vow, now is the time for the ICE to act swiftly, efficiently, and tangibly. Poland will continue by various means and at various levels to support the tribunal and the office of the prosecutor. But like other states' parties, we expect results. Distinguished delegates, justice is due to all victims of conflicts which the ICC deals with, no matter where they occur. The court's current investigations cover practically every region in the world. This is a desired development and a source of satisfaction for states' parties. However, for the court to be truly universal, to be able to prosecute international crimes committed by any person and in any place, the universal ratification of the Rome Statute by all states is needed. We should strive for such an optimal solution, for only then will the system of international justice based on the Rome Statute become airtight and effective. I would like to take this opportunity to appeal to all states that have not yet done so to become party to the statute. Madam President, the growing volume of investigations and trials requires even more resources. This comes at a time of economic crisis when the finances of most governments are deteriorating. But even so, I hope that during this year's session, the states parties will be able to agree on a budget that allows the court to cope with its heavy caseload. Madam President, let me conclude by calling on everyone to redouble their efforts to cooperate with and support the court so that justice is done. Justice is something the world needs now more than ever. We still have a long road ahead before we achieved that aim. But Poland believes we can get there if we work together. Thank you.
I thank His Excellency and invite His Excellency Mr. Urmas Reinsalu from Estonia.
Madam President, distinguished delegates, Estonia aligns itself with the statement made on behalf of the European Union and its member states. Estonia commends the International Criminal Court for its remarkable 20 years of activities. For that occasion, Estonia organized in May this year, in cooperation with the ICC and the Trust Fund for Victims, an online seminar on the role of the ICC in fight against impunity and delivering justice to victims. This year once again reminded us that international community must put special emphasis on ensuring justice and accountability for atrocity crimes and express our firm support to the role and mandate of the ICC. It is of utmost importance that the most serious crimes of concern to the international community as a whole would not go unpunished. The Russian, unprovoked and brutal genocidal war of aggression against Ukraine has triggered deep global concern. If we do not respond decisively to Russia's aggression on the 21st century, the sovereignty and equality of all the states is under threat. In liberated areas, the Russian armed forces have left behind mass graves with dead bodies of civilians and servicemen, and torture chambers. The intent to inflict pain and cause suffering to the Ukrainian people is shocking and utterly inhumane, with no respect shown to human life and dignity. We commend the ICC prosecutor Khan for swift action and opening the investigation in the situation in Ukraine after submission of a referral by 43 states. Criminal proceedings have also been initiated in Estonia. We have joined, together with a number of other states and the ICC, the international investigation team established with the assistance of Eurojust. And we commend that Eurojust and the Office of the Prosecutor of the ICC have published practical guidelines for civil society organizations on documenting core international crimes, which is practical assistance in efforts to collect and preserve information and evidence that may become admissible in court. The Rome Statute reserves a unique role for the Security Council as it can refer situations to the ICC that would otherwise not fall under its jurisdiction, but the gravity of the situation requires action. We regret that Russia is holding the Security Council hostage with its misuse of veto. Veto prevents the Security Council from discharging on its important function entrusted upon it by the UN Charter. It has primary responsibility for peace and security. We urge states to refrain from using a veto in cases of mass atrocity crimes. as the ICC does not have jurisdiction over the crime of aggression in Ukraine, Estonia supports Ukraine in their endeavors to establish a special tribunal so that full accountability can be ensured, including of the head of state and its accomplices. The special tribunal will be complementary to the ICC, not in conflict with it. We should give our full support to the ICC to assist it to cope with the rapidly growing workload. Estonia was one of the first countries to respond to the request by the ICC and has seconded 4 national experts. We should take the financial needs of the ICC seriously, and we call upon all states to make their payments at the earliest possible time. Estonia also supports the increase of the budget for next year as suggested by the Committee on Budget and Finance to allow the court to efficiently fulfill its tasks. Madam President, we would like to express our appreciation and support to the work of the Trust Fund for Victims in offering reparations and assistance to victims, their families and communities. As a regular donor, we would like to repeat our call for all states to consider making voluntary contributions to the Trust Fund. During a monitoring visit to northern Uganda this autumn organized by Ireland and the Trust Fund, we were glad to ascertain the real impact of the work done on the ground and that it really brings benefits to the victims and local community. To conclude, we call on state parties to the Rome Statute to have not done so to ratify Article 8 bis on crime of aggression. We also call on those states that have not done so to ratify the Rome Statute to further strengthen the system of international criminal justice and enable it to provide truly universal protection. And finally, we are particularly glad to inform you that Estonia will nominate a candidate to the post of a judge of the ICC in 2023, and we ask for your serious consideration and support to our candidate. Thank you.
I thank His Excellency and invite His Excellency Mr. César Rodrigo Landa Arroyo, Minister of Foreign Affairs of Peru.
Señora Presidenta.
Madam President of the Assembly of States Parties, Mr. President of the ICC, honourable members of the Bureau, members of civil society who are here with us today, ladies and gentlemen, I wanted to take this occasion to commend the President of the ASP, Madam Silvia Fernandez de Gurmendi, for all of her work and all of for those who are working as coordinators of the working group of The Hague, and the coordinator for informal consultations and the Hague Working Group and the New York Working Group. It was 20 years ago when a handful of member states got together and decided to create this International Criminal Court. This was a major step forward for the international community. And then finally, with the Rome Statute coming about, this was the start of a life for the International Criminal Court. And it, to this day, can count on Peru's support. Given the impact of the COVID-19 pandemic and the outbreak of conflicts in various parts of the world, the court is as relevant as ever. And in this regard, we wanted to understand and underscore the importance of having equitable geographical distribution in the organs of the court and to ensure diversity among the regional groups. And this will help with its universalization. Peru has proven time and again its commitment to the court. We were one of the most affected by the COVID-19 pandemic, and to this date, we have nonetheless managed to honor all of our financial commitments vis-a-vis the court. And we call on all other states parties to do the same. We wanted to state on record how pleased we are to domesticate into our national law the Amendment Article 8 bis on the crime of aggression as was adopted in Kampala in July 2010. and the review conference, which again we feel is important for strengthening the Rome Statute system. We want to thank the working groups for all of their work, and we think that the states need to lend their full support to the recommendations stemming from the independent expert review. We also want to welcome the work undertaken by Judge Luz del Carmen Ibáñez Carranza, first Vice President of the court, and we hope that her experience and expertise will help further strengthen the court as it moves forward. We also wish every success to the prosecutor, Mr. Khan, and we hope that the incoming registrar will have every success. By way of conclusion, Madam President, we just wanted to extend our acknowledgement and best wishes to all of the staff in the registry, and the same goes for the civil society representatives who are here working hand in hand with the court to make sure that the world it can finally do away with impunity and see the reign of peace and security for one and all. Thank you.
I thank His Excellency for his statement, and I invite His Excellency Mr. Ratislav Kačer, Minister of Foreign and European Affairs of Slovakia.
Madam President, while aligning myself with the statement made on behalf of the European Union, I have the honor to address the Assembly with additional observations in our national capacity. As we celebrate the 20th anniversary of the entry of the force of the Roma Statute, I would like to reiterate Slovakia's continuous support for the mission, integrity and independence of the International Criminal Court. I also want to express our sincere appreciation to the court and its officials, as well as the civil society, for their tireless effort to end the impunity for the most serious crimes of the international concern. Madam President, this week, events serve as a stark reminder of how fragile peace among the nations can be, and that it should never be taken for granted. A full-scale invasion of one of the sovereign states into the territory of another sovereign state that constitutes a blatant violation of international law. It aims at the very core of the international system based on a resolution of disputes by peaceful means. Now, we understand all too palpably the importance of the international criminal justice, which admittedly sometimes is a bit slow, but eventually reaches all of those responsible for the most horrendous crimes of concern to the humankind. Justice is crucial to and firmly embodied in the notion of peace. Slovakia, as a neighboring country, feels particular responsibility for ensuring accountability in the situation east of our borders. We have supported and engaged in multiple efforts aimed at independent investigation of the atrocities in Ukraine. Among other things, Slovakia, along with other 42 states, state parties referred to the situation in Ukraine to the office of the prosecutor. Nevertheless, I would like to reassure all colleagues and partners that Slovakia supports sustainable and adequate allocation of resources to all ongoing cases and situations. Moreover, we continue to actively explore modalities of a very practical support for the fulfillment of the court mandate. The ICC has achieved considerable progress in its investigations and prosecutions in situations across different continents. However, the court cannot live up to the expectations without adequate support from the state parties. Along with the duty of cooperation pursuant to the Chapter 9 of the Rome Statute, we all bear a moral obligation to support the court and its integrity. This allows the court to conduct independent and impartial investigation and prosecutions. Justice must be done, and justice must be seen to have been done. Let us not forget thousands of individual victims. In this regard, we appreciate the work done by the Trust Fund for Victims, fulfilling both its reparations and assistance mandate. I'm pleased to announce that in addition to its regular contribution to the ICC budget, Slovakia will again provide a voluntary contribution to the fund this year. The Assembly shall adopt its recommendations to the judges on the election of the next registrar. In this regard, let me express my highest appreciation for the work of Mr. Piz-Lewis. His leadership, commitment to the mandate of the court, and his excellent managerial skills have been instrumental in making the court a more resilient organization. Finally, we would like to encourage those states that have not yet ratified the Rome Statute or its amendments to do so. Universal ratification of the Rome Statute and its amendments lies at the heart of the promise of the ICC and international justice more generally. To conclude, Madam President, Slovakia wishes to recall its unwavering support to the court. It remained determined to continue working constructively with all parties towards a successful session of the Assembly and in a broader perspective towards an effective system of international criminal justice. Thank you very much.
I thank His Excellency for his statement, and now I invite His Excellency Mr. Jan Borg, Minister for Foreign and European Affairs and Trade of Malta.
Madam President, at the outset, Malta fully aligns itself with the EU statement being delivered by the Czech Republic on behalf of the European Union. I'm greatly honored to address the Assembly of State Parties and would like to thank you, Madam President, the Bureau, the Secretariat and other facilitators in preparing and making the necessary arrangements for this Assembly and for presenting us with renewed opportunities to reform, to regenerate, as well as to reinforce the Court. Allow me also, Madam President, to pay tribute to the commitment and dedication shown by all the officials of the Court over the past year, and not least by President Hofmanski and the judges of the very same Court. As we prepare to welcome a new registrar, I wish to pay tribute to the outgoing registrar, Peter Lewis, who leaves a solid legacy for the new registrar to build upon. During their first year in office, Prosecutor Khan and his deputies have shown remarkable leadership. I wish to once again reassure him and his office of Malta's unwavering support, which this year we sought to demonstrate also through a voluntary contribution. This year we commemorated the 20th anniversary since the entry into force of the Rome Statute and the setting up of a permanent international court, a court that seeks to bring to justice people responsible for the most atrocious crimes, individuals that national courts were unable or unwilling to pursue. This milestone was sadly overshadowed by the outbreak of a war of aggression on the European continent, the Russian invasion on Ukraine's sovereign territory. Increasingly, we receive reports of war crimes and crimes against humanity being committed not too far from where this Assembly is gathering. Against this challenging backdrop, we reiterate the Court's indispensable role in the rules-based international order and reaffirm our resolute commitment to our obligations under the statute. During the past year, the role the Court has played in ensuring accountability of individuals was as crucial as ever, with the Court's trial activity reaching unprecedented levels. Malta welcomes the opening of new investigations by the prosecutor, most recently those concerning the situation in Ukraine, where numerous state parties, including Malta, have jointly referred the situation in Ukraine to the Office of the Prosecutor for investigation. There has never been a more pressing time for state parties to renew their commitment to the court, to reaffirm our beliefs and our adherence to the values and principles of the court. No efforts must be spared to ensure timely accountability for long-term peace and justice. Madam President, as an elected member of the United Nations Security Council for the coming 2 years, Malta notes that improvement in the relationship between the Court and the Security Council is certainly desirable. We know that so far only 2 situations have been referred to the Court. Malta also attaches great importance to the principle of universality and believes that progress can only be made through a concerted effort and commitment and continuous and meaningful dialogue. As state parties, we must also ensure that survivors' voices are heard and that their suffering is duly acknowledged. The salience of reparative justice, which is both a unique and a key feature of the Rome Statute, must not be undermined. It is for this reason that this year, to demonstrate our firm support to the ICC and its indispensable role in delivering justice to victims of heinous crimes, Malta has made a second voluntary contribution to the Trust Fund for Victims. Madam President, in closing, Malta reiterates its resolute commitment to the Court, its values and its principles. We encourage fellow state parties to look to the coming year as a year which is presenting us with a unique opportunity to play our role in further strengthening the Court and reinforcing its role in ending impunity and bringing perpetrators of war crimes, crimes against humanity, the crime of aggression and genocide to justice. Thank you.
I thank His Excellency and invite His Excellency Mr. João Gomes Cravinho, Minister of Foreign Affairs of Portugal.
Madam President, distinguished delegates, I am most honored to address the 21st session of the Assembly of States Parties to the Rome Statute of the International Criminal Court. I wish to begin by stating that Portugal shares the views earlier expressed by the Minister of Foreign Affairs of the Czech Republic, my dear colleague Jan Lipavsky, on behalf of the European Union and its member states. Nevertheless, I would like to underline some aspects that are relevant to my country. Portugal would also like to commend the President of the Assembly, the President of the Court, the Prosecutor and the Deputy Prosecutors elected during the last sessions of this Assembly, and to express our sincere recognition for their valuable contribution to the work of the International Criminal Court. Madam President, in light of the 20th anniversary of the entry into force of the Rome Statute that we are celebrating this year, it is timely to critically examine the achievements and challenges of the ICC. It is worth recalling that when established back in 2002, the International Criminal Court was called the most ambitious initiative in the history of modern international law. Today, we urge this Assembly to restate our collective ambition and express our unwavering support for the pivotal role that the ICC plays towards accountability for the most serious crimes that regrettably continue to threaten the peace, security, and well-being of the world. Madam President, as the world's permanent international criminal court, the ICC represents a historic achievement of humankind. It plays a central role in the fight against impunity, bringing justice to victims, and in the prevention of the commission of atrocity crimes, contributing in a very significant way to the advancement of the rule of law and stable, peaceful societies. In this vein, we must continue to actively work together towards the universality of the Rome Statute and the strengthening of the international criminal justice system, alongside other accountability mechanisms and national prosecutions. Madam President, the Assembly of States Parties is the right forum to collectively discuss additional and more efficient forms of cooperation and to seek to improve the decision-making processes and ultimate impact of the court's work to accomplish its mandate. Portugal is committed to working with you and with every delegation towards a successful session of the Assembly of State Parties. Recent and ongoing events in Ukraine have more than shown us the need for a strong ICC and for all states to cooperate with the court. Without such cooperation, the court will not be able to carry out the mandate it was given by the Rome Statute. In this context, I would like to reaffirm our commitment to continuing supporting the work of the Office of the Prosecutor, including by providing national experts on a secondment basis to support such work. Let me end my statement by pledging once again the support of Portugal to the work of the International Criminal Court and by calling upon all states to keep the same ambition that was present at its inception back in 2002 towards a more peaceful and a fairer world. Thank you, Madam President.
I thank His Excellency for his statement, and now I invite Her Excellency Ms. Hadia Lahbib, Minister of Foreign Affairs, European Affairs, Foreign Trade and the Federal Cultural Institutions of Belgium.
Madame la Présidente de
Madam President of the Assembly of States Parties, Mr. Prosecutor, Mr. Registrar, ladies and gentlemen, distinguished guests, I should like first of all to state from the outset that Belgium aligns itself fully with the statement on behalf of the EU. We see that the peace is fragile everywhere around the world, and despite the Charter of the UN forbidding the use of force, we've seen violence all around the world and war and conflict all around the world. In absolutely every region. And this is the responsibility of the international community to fight against this kind of impunity. It comes first and foremost down to the individual states, every state is called upon by the Rome Statute to cooperate fully with the court, as well as to ensure that the respect of the court's impartiality and independence is sacrosanct. And that is why it's so important to contribute on time and in full to the court's budget so that the court can fulfill its mandate. Madam President, the support given to the court is of vital importance, but it can't be selective. The prosecutor had this year to call on additional financial contributions and staff so as to cope with the unprecedented workload that the court is facing. My country was able to answer that call by submitting an extra 500,000 euros to the cause. But this needs to be reflected in the ordinary budget of the court so that it becomes fully sustainable. Here again, and this year again, Belgium has been flabbergasted by the amazing work conducted by the court. And yet, much of the work that is done by the court is actually invisible to its state parties because of the confidentiality of the work undertaken and the work that is done behind the scenes. Belgium would like to extend its most sincere thanks to Mr. Registrar as his mandate comes to a close, and we would like to extend the reassurance to the incoming registrar that we will continue to fully cooperate with the court. And despite all of the heinous crimes we've mentioned, some of them are particularly monstrous, such as sexual violence and violence against children. And my country attaches particular importance against impunity for these classifications of crimes. We encourage the court to continue its efforts in this regard, and we pledge our full support thereto. The amendments for adopted in 2010, 2017, 2019, I think will further strengthen the court. Not only thanks to the definition of the crime of aggression, but also the heinous issues of chemical weapons or starvation as a method of warfare. And we think that this is part of the dissuasive function of the court, and it's really important for ratifications to continue so that the court can be fully fully universal. Liechtenstein, Switzerland, and Belgium have been particularly active in working against the crimes against the environment, and that is why perpetrators of environmental crimes need to be punished as well. Belgium has been working on reforming its criminal code, and my country is reiterating its provisions and is prepared to contribute to reflection on crimes of environmental crimes, such as what we call ecocide. Victims deserve to be acknowledged, and we have a duty to give them the justice they deserve. We are very attached to the court's role vis-à-vis victims, and that is why in the coming year, 2023, we'll be regularly continuing with our financial support to the Trust Fund for Victims, and we call on other states to do the same. The recent observation mission to Uganda, organised by Ireland, showed very clearly just how important the fund's work and the work of the fund's partners is on the ground. We'd like to take advantage of this general debate and to recall how a new treaty concerning extrajudicial processes for some of the most serious crimes is underway. And remember that punishing crimes nationally is actually one of the best forms of complementarity. In fact, we've got a side event organized by Belgium with Argentina, Mongolia, Netherlands, Slovenia, and one other country in this regard. Thank you.
Thank Her Excellency for her statement and invite His Excellency Mr. Tobias Billström, Minister for Foreign Affairs of Sweden.
Madam President, I am honored to address the Assembly of States Parties. Sweden aligns itself with a statement made by the Czech Republic on behalf of the European Union and its member states. Allow me first to express my sincere appreciation to the Court and all its officials. Your work continues to make significant contributions to ensure accountability for perpetrators of the most serious crimes and justice for victims. I would in particular like to thank the Registrar, Mr. Peter Lewis, as he reaches the end of his 5-year term at the ICC. We commend his relentless work for the effective functioning of the Court, his tireless efforts towards gender equality and a better working environment at the Court. Civil society organizations were instrumental in the creation of the Court almost 25 years ago, and they continue to be crucial for the Court and its states parties. It goes without saying that threats and intimidation directed at civil society organizations cooperating with the Court are unacceptable. Madam President, Sweden has been a steadfast supporter of the International Criminal Court since its establishment. The fight against impunity is integral to a rules-based international order, and the ICC is the key institution in this quest for accountability. Only a truly universal court can fulfill its mandate completely. We urge all states that have not yet ratified the Rome Statute to do so, to give victims everywhere access to justice. I am pleased to announce that Sweden early this year deposited the instruments of acceptance of the Kampala amendments, including the crime of aggression. Madam President, the Court is faced with an unprecedented workload, as it is currently active in 16 situations. In early March, Sweden was one of the 39 state parties that referred the situation in Ukraine to the prosecutor, who promptly proceeded to open an investigation that encompasses any past and present allegations of war crimes, crimes against humanity, and genocide committed from the 21st of November 2013 onwards. During the year, a number of state parties, including Sweden, have also provided the Office of a Prosecutor with voluntary financial contributions and seconded personnel. It is important to underline that these contributions are not earmarked solely for one specific situation, but should be seen as an exceptional measure to assist the Court in fulfilling its mandate. The court can only fulfill its mandate if we put it on a long-term sustainable financial footing. We call on all state parties to pay their contributions in full and on time. Late or unpaid contributions severely hamper the work of the court, prolong investigations and trials, and delay justice for victims. Madam President, the Trust Fund for Victims is a cornerstone of reparative justice for the victims of the most serious crimes. I am proud to say that Sweden has been the largest contributor to the fund, with total contributions of approximately 3 million euros during the last 3 years. However, this is not enough. The fund depends on voluntary contributions to fulfill its mandate. We call on others to join in contribution to this important work. Madam President, states' full cooperation with the court is essential for its ability to carry out its mandate. Witnesses must receive protection, outstanding arrest warrants must be promptly executed, and states parties must share the burden of enforcement of sentences. Sweden stands ready to share its experiences of relocating witnesses with other interested state parties. Madam President, the review process of the Rome Statute system is still ongoing. Many of the recommendations of the independent experts have been assessed and is implemented over the past 2 years. We salute the considerable work and significant achievements of the court in this regard and welcome further efforts to enhance the governance and management of the court, including its working culture. We must continue to engage in this process and work together for the benefit of a stronger, more efficient and more resilient court and Rome Statute system. Madam President, the ICC was established to prevent and investigate the most serious crimes, regardless of who commits them. The court's heavy workload, which is a reflection of the dire times we live in, shows how much we need it. We look forward to working constructively with all state parties, officials of the court, and members of the civil society to achieve a successful outcome of this assembly. Under your able leadership, Madam President, I thank you.
I thank His Excellency for his statement and now invite His Excellency Mr. Gabrielius Landsbergis, Minister of Foreign Affairs of Lithuania.
Dear colleagues, while aligning with the statement by the EU, let me focus on a few issues of particular importance to Ukraine and all of us. This year marks 20 years since entering into force of the Rome Statute. What was once a vision of a few has now grown into a fundamental pillar of international criminal justice and a beacon of hope for the world's most vulnerable and oppressed. Lithuania's support to the ICC is unshakable, as we affirm our commitment to defend the principles of the Rome Statute and ensure accountability for the most horrendous crimes. The restless devotion of the International Criminal Court, its judges, the prosecutor, and the whole team deserves our sincere appreciation and gratitude. To help tackle ever-increasing workload, Lithuania has supported additional financial contributions and secondment, with full respect to its impartiality. We have also contributed to the Trust Fund for Victims that ensures reparations for harm suffered by the victims of crimes and their families. Lithuania calls on all states to fully honor their financial obligations and further contribute to the work of the court. Madam President, I address you from Ukraine, where for over 9 months Russia's unprovoked aggression has horrified the world by complete disregard to the most basic fundamental international norms. The ICC has been among the first to react, and I commend the prosecutor for his active involvement in a joint effort with Ukraine and the joint investigation team, of which Lithuania is a proud member. While we expect and encourage the ICC to continue its pivotal role in prosecuting the war crimes, genocide, and crimes against humanity committed in Ukraine, we have to admit that the court does not have a jurisdiction to prosecute the crime of aggression. Since aggression is the supreme international crime from which all other crimes flow, such jurisdictional gap risks to become a major source of injustice. Sustainable peace would be unimaginable if key political and military masterminds who lead this aggression were allowed to escape justice. It is thus our strong belief that the Special Tribunal for the punishment of the crime of aggression against Ukraine has to be established to complement the role of the ICC with regard to the crime of aggression. We also consider that the most preferable and feasible way to establish such tribunal is through the resolution of the UN General Assembly. Its universal representation would bring global legitimacy to the tribunal and go a long way in addressing crucial issues of impartiality, immunities of state officials, and cooperation with the tribunal. We also support the establishment of the interim prosecutor office that would be responsible for collecting crucial evidence of aggression in complementarity with the ICC and Ukraine's prosecutors. There is no doubt that serious legal and political questions still lie ahead, but that should not discourage us from rapidly forging ahead. Justice delayed is justice denied, and we are all in agreement that Russia's unprovoked aggression against a sovereign nation cannot be left without an appropriate legal response. Our failure to act, however, would not just mean that those responsible for the atrocities would evade justice. It would further embolden Russia and other aggressors to undermine international order and put us all at even greater risk. Thank you.
I thank His Excellency for his statement, and now I invite Her Excellency Ms. Catherine Colonna, Minister for Europe and Foreign Affairs of France.
Chers collègues,
Dear colleagues, ladies and gentlemen, 2022 marks 20 years of the Rome Statute. It was to address the universal need for justice for victims of atrocities throughout the world that the International Criminal Court was created. There can be no peace without justice. On this anniversary year, France reiterates its total support for the first permanent International Criminal Court, which is more necessary than ever. 2022 also saw Russia's war of aggression against Ukraine, a flagrant violation of the fundamental principles of international law, in contempt of the rules-based international order. The war, for which the Kremlin is wholly responsible, continues to bring atrocities, murders, deliberate attacks on civilians, torture, rape, and deportations. Those responsible for these crimes, those who committed, ordered, or planned them, must answer to their victims and the international community. And that is why we support the investigations by both the court's prosecutor and the Ukrainian authorities through financial, technical, and human contributions. The court must be supported everywhere, in The Hague and in the field. And we know that we can count on the quality of its men and women who work for a fairer world. France is presenting Nicolas Guillou's candidacy to a judge's post in the court in 2024, and I'm convinced that his great experience in international courts will benefit this institution that is key to fighting impunity. We greatly value your support. Ladies and gentlemen, at 20 years old, the International Criminal Court is still a relatively young institution. It's an institution that, to fulfill the tough mission that we've entrusted to it, needs to be defended today and strengthened in the long term. Together, we must ensure that its reform will enable it to gain further in speed and efficiency. This is an essential project in which France will play its full role. Thank you.
I thank Her Excellency for her statement, and I invite His Excellency Mr. Ioannis Kasoulides, Minister of Foreign Affairs of Cyprus.
Madam President, ladies and gentlemen, dear colleagues, I am grateful for this opportunity to address the Assembly of State Parties on such an important occasion, the 20-year anniversary of the International Criminal Court. During these last 20 years, the International Criminal Court has gained international recognition for its independence, impartiality, as well as the high standard of its judicial, prosecutorial, and investigative activities. I am sure that all of us remember the sense of responsibility that fell upon our collective shoulders on the 1st July 2002, when the Rome Statute entered into force, signaling the beginning of the establishment of the ICC. It was a historic moment for justice. It was also a defining moment for the victims of the most serious crimes faced by humanity, those of genocide, war crimes, and the crime of aggression. Although the Rome Statute makes it very clear that the primary responsibility for prosecuting such crimes lies with states, the ICC is regarded by many as a life vest when faced with the inability or unwillingness of states to act. Moreover, since its inception, the ICC has managed not only to contribute to the development of international criminal law, but also to increase legal certainty in jurisprudence on the issue. In addition, as a direct consequence of its role, and despite the fact that it is a judicial body and can only contribute to the legal sphere, the ICC has become very relevant in the area of peace. The importance of the court is evident if one looks to its continually augmenting workload. The Office of the Prosecutor has opened through new investigations in the last 12 months alongside the rest of the cases and open investigations it is dealing with. What is significant here is the fact that two of these, those pertaining to Venezuela and Ukraine, have been opened following a referral by state parties, highlighting once more the prominence given to the court. Another indication of the trust attributed to the work of the court is the high participation of victims in the proceedings. In fact, the ICC has been a valuable lifetime for victims through the continued implementation of reparation and assistance orders. As a strong supporter of the ICC and its work, Cyprus welcomes its active engagement in the review process, aiming at enhancing the effectiveness and performance of the institution and the wider Rome Statute system. We will continue to work for the universal ratification and full implementation of the Rome Statute and urge all parties to do the same. My country's commitment, which is shared by other state parties, to protecting the rules-based order from existing threats and uncertainty, and supporting the work of the ICC is unwavering. What is urgently needed is to encourage acceptance and cooperation between the court and non-state parties, including the United Nations, in order to protect judicial and prosecutorial independence and integrity. Madam President, no institution can function or fulfill its obligations without adequate financial resources. We are honored that Cyprus will remain as facilitator for the 2023 budget. Rest assured that we will continue to act as an honest broker to achieve the best end result, given the need for the court to deliver upon its ever-increasing mandate. It is inspiring to see that despite the difficult financial environment and the projected hardships that our countries will face, especially during the winter months, state parties have not stopped contributing to the court and the trust fund for victims of atrocities. This lies as a testament of the importance of the work carried out by the ICC. As many have said before, there can be no lasting peace without justice. If we remain committed to our aspirations, to ensuring that all manner of war crimes and crimes against humanity are investigated and prosecuted, and to fighting impunity, then just maybe we will have a chance at peace. Thank you.
I thank His Excellency for his statement, and now I invite His Excellency Mr. Santiago Cafiero, Minister of Foreign Affairs, Trade and Worship of Argentina.
Madam President, in my capacity as the Minister of Foreign Affairs, I send out warm greetings to you at the outset of this Assembly of States Parties. This year, we will be celebrating 2 decades since the Rome Statute came into force, which remains the cornerstone of international criminal justice. Recently, we had the honor in Buenos Aires to have a visit from the President of the Court, who was received by Alberto Fernandez, our head of state. And this demonstrated that the ICC is a critical tool in the fight against impunity, the promotion of human rights, and the consolidation of the rule of law throughout the world. Current events pose many challenges to multilateralism in general. The preservation of judicial independence is vital for the court to be able to fulfill its mandate properly. Madam President, Argentinian experience shows just how useful international human rights law can be when it comes to making sure that none of those accountable go off scot-free. We know that when we think about the Rome Statute is based on the prime responsibility of states parties to carry out investigations and to look into the most serious crimes that fly in the face of international condemnation. I would like to mention the initiative that we've taken in the field of international cooperation for investigating and prosecuting the crime of genocide, crimes against humanity, war crimes that was promoted by Argentina, Belgium, Senegal, and others. Madam President, Argentina is aware of the fact that there is a need to deliver justice to victims. They have rights to reparations. A society is more democratic when it is closer to the values of memory, truth, and justice. From 1985 in our country, more than 1,300 agents of repression in Argentina were sentenced. And our country will continue supporting the work of the court and its judicial independence. Thank you.
I thank His Excellency for his statement, and now I give the floor to the last speaker of our today, who is Lord Ahmad of Wimbledon, Minister of State for the Middle East, South Asia, UN, and the Prime Minister's Special Representative on Preventing Sexual Violence in Conflict of the United Kingdom of Great Britain and Northern Ireland.
Mr. President, Your Excellencies, distinguished delegates, I welcome this opportunity to address the Assembly on behalf of the Government of the United Kingdom, and I pass on the best wishes of and a message of support from the UK Foreign Secretary. On its creation, the ICC was described by the then UN Secretary General as a giant step forward in the march towards universal human rights and indeed the rule of law. It was a watershed moment in international justice, intended to help tackle the culture of impunity that characterizes so many armed conflicts around the world. A court of last resort, the ICC was ready to take action when a country could not or would not investigate and prosecute those alleged to have committed international crimes. For our part, the UK remains absolutely committed to this vision. We remain determined that the court should be an effective means of ensuring that all victims of the most serious international crimes have access to justice. And we also remain determined that all would-be perpetrators know that they can and will be held to account for their actions. Since the ICC's establishment, we have seen notable successes in situations under the court's purview. The United Kingdom has been proud to support the work of the court. In addition to contributing to the annual budget, we enforce sentences, we protect witnesses, and we are proud to support the work of the Trust Fund for Victims. It was as a great supporter of the ICC that in 2018, the United Kingdom, along with other like-minded state parties, called for action to reform and indeed strengthen the court. We therefore welcomed the establishment of the independent expert review, recognizing that the court could improve in a number of fundamental areas, from leadership to efficiency, from working culture in the organization, to its expertise. The resulting report was the basis for a process for strengthening the court itself, and we thank the court and the review mechanism team for taking this important work forward. And we also welcome that progress has been made. However, important work, as we all recognise, still remains to be done. Despite, indeed because of, the many pressures the ICC faces, now is not the time to step back. This year, we look forward to focus on the implementation of key recommendations, building on the improvements already made. Indeed, this will be crucial to continue strengthening this important international court. We also look forward to action to ensure the introduction of an effective and practical tenure policy at the court. These steps will allow us all to continue to build a more effective and efficient ICC that ultimately serves its objective and is best placed to deliver justice for victims. This objective is one that remains both timely and relevant. When we look towards Russia's brutal, illegal, and unjustified invasion of a sovereign state, Ukraine, and the subsequent overwhelming evidence of atrocities against the civilian population, including abhorrent allegations of crimes of sexual violence, has once again brought into sharp focus the need for both accountability and justice, and the role of the international community in holding perpetrators of crimes to account. I assure you, both the Foreign Secretary and I welcome the court's work in investigating these allegations and the ICC's ongoing work to ensure all victims have access to justice wherever crimes take place within the court's jurisdiction. Since its creation, the ICC has been instrumental in ensuring that impunity is not the default. That is a role I know the court will continue to play, and it's an institution we, the United Kingdom, are extremely proud to support. In that regard, it is only right to end this statement of mine by paying tribute to a real pillar of this institution, the Registrar Peter Lewis, who steps down after 5 years of distinguished service to the ICC. On behalf of the United Kingdom, we thank Peter for his excellent work, his stewardship of the court, often through what have been quite trying and difficult times. And we all wish him well in whatever comes next. Looking ahead, we of course look forward to also supporting the next registrar to carry on this important work. Thank you so much.
I thank His Excellency for his statement. And now we are coming to the end of our meeting. I would like to thank you all, and I thank all the distinguished speakers today for their important statements and the support pledged to the court in the fulfillment of its mandate. Tomorrow, we will start with a statement in person of Her Excellency Ms. Rose Mutombo Kiese, Minister of State, Minister of Justice and Garde des Sceaux of the Democratic Republic of the Congo. Unless there are any requests for the floor, I see none. This meeting is adjourned.